order, and as we left before the break, we're yet to decide on the way forward. I will let Honorable George, because if we start interacting like this, then it will be a bit in a disorderly fashion. So let's try and come up with a roadmap. How are we going to tackle it? Honorable George.
Thank you, Mr. Chair. Mr. Chair, I propose that we start at the beginning, as the song says. It's a very good place to start. And we ask the professor to lead us, to explain to us to explain to us the reasoning behind Articles 1 to 14, and perhaps every time he does it, he can indicate whether that part changes or whether it's the same, and then explain to us the context, and then we'll do another part and another part. And I think we will see as we go along that some of these early bits are going to go quite fast.
Okay, thank you, Honorable George. So it's clear now. So we'll take the series of articles actually put together, like 1 to 14, 15 to 18, and we'll progress from there. All right? Yes, Professor, over to you.
Thank you. Those articles 1 to 14 are basically a restatement of existing rules. In the present law, there are a number of vacant provisions, and there is not a very good order of those provisions. So I think the main things to say about 1 to 14 are, first, the code has been set out as a contemporary act. In other words, it starts, this is the Civil Code of Seychelles, which is not in the present, and then the standard pattern, this act binds the state, and a few, very few key definitions, and then key concepts. For instance, Article 4 is already there. It's the present Article 4 is in the current provisions in Section 8 of the Act that introduced the current law. So there's a reordering, but no change, and the hope of the desire of the committee was for there to be a slightly more predictable pattern of provisions. There is some change in Article 7 that corresponds to the current Article 5, which says that no decision of a Seychelles court absolutely binds another court. And the practice, I'm told, in the Seychelles courts is that over the period since independence, there is a pattern. Typically, the Supreme Court will follow prior decisions of the Court of Appeal. And in fact, it's very inefficient if that were not the case. Otherwise, there would be constant cases going to the Supreme Court in order to get a view of the law which is different from that from the Court of Appeal, and then ultimately more appeals. So the goal was to firm up, if you like, to build on the current pattern in the courts, and that is that the best statement of the law of Seychelles today is that you find in the decisions of the Court of Appeal. So we have an order of precedent and an exception for those cases where, on reflection, the Court of Appeal thinks its earlier decision was not right. So that is set out in 7, and it is a statement of the current judicial practice, which has developed over the 40 years from your present Article 5. The next provisions, I think, are consistent, but Article 10 seeks to correct an anomaly in the existing law and also to reflect the constitutional provision of equality. The present rules in this area are found in the Domicile Act. And if you look in the consequences bill, you'll see the Domicile Act is repealed. The Domicile Act refers to the law of England on these matters. Your domicile decides basically who you are. Are you adult? Are you a child? Are you legitimate? Are you illegitimate? That is determined by, under the English law, by your domicile. And what is your domicile is determined basically by your parents. And if you're a woman, it's determined first by your father and secondly by your husband. So that is clearly unconstitutional. So the committee decided to retain the concept of domicile, which is well known, but to give it the content set out in Article 10, which follows modern treaty practice to say that what determines your status, the nature of your personality, is a matter of fact. Where is your real home? Where is your habitual residence? So for a married woman, it isn't where is your husband living, it's where are you based? It doesn't depend whether your parents were married or unmarried. It simply sets out a set of standard criteria for determining, for instance, your capacity. In some countries, people can make a contract at age 16, in others at 21, in others at 20. So which law determines that? It is the law of your domicile. The Honourable George invites me to engage in a semantics argument or debate. This is the use of the French word. English domicile has no E on the end. The French word means the place where you can be contacted. That is, some court process has to be delivered to you. It's delivered at your domicile. But the English law is a totally abstract concept, which is the law, the country that determines your status or capacity. The current law unfortunately uses both spellings, more or less indiscriminately. So the English, the conceptual view was chosen, and that is domicile, English, no E, and that is to avoid confusion with things that could change, which is your address for delivery of official documents. So that...
Yes, Honourable.
I'm a bit confused now because the English domicile has an E at the end. Yeah, I'm looking at it right now. The country that a person treats as their permanent home or lives in and has a substantial connection with. So the English domicile has an E and the French doesn't.
Oh,
So my question is, why are we keeping the French domicile, but when we want the code
to be your own, in fact, because this is neither French nor English. It has moved from a technical expression to a factually based set of criteria. Now, the E and the absence of E, I think I was led into...
Yeah, you were led not into temptation.
I was,
but
yes.
into something completely different. I think, if I remember correctly, I think we wanted to make sure that we would not fall into the trap of treating domicile in the legal context with the place where you live,
Yes.
which is the factual context. We wanted there to be a distinction. If you put the domicile, everybody thinks automatically that this is your home where you are. Whereas domicile in the abstract is something, can be your home, but it does not necessarily have to be your home, which is why we used that word to distinguish between the two.
Yes, but given that here in 10.1 you are giving the definition as the country. It's not your address 25
No.
Serret Road, but it's the country.
Yes.
And domicile with an E goes in that direction, meaning the country of habitual residence, whereas domicile without the E can in fact mean 25 Serret Road.
In French.
In French.
So it's,
I mean, as I say, I'm not a lawyer.
No.
But I just want, especially that we want something modern where
Yes.
which people will understand. I would argue that domicile with an E would in fact be more appropriate, and it would be clearer to everyone, and it would be in line with Dr. Google.
yeah. I'm not too sure about the reliability of Dr. Google, but in fact, in this context, the committee did have a view, and this was its view. It, in fact, here does not really matter whether the Assembly puts an E or leaves one off, because it is redefined. it is the definition which matters, and it was considered useful to keep the idea of domicile, but give it new content to be consistent with international treaty practice.
I'm Anglican, so I suggest perhaps we may consider what we do elsewhere in the code, which is where there is a English word which has a French translation, to put that French translation in brackets. So we could have domicile with the E, and then afterwards domicile, if that doesn't complicate matters. If it does, then ignore.
With the E.
Yes, Honorable Wao.
Yes, thank you, Mr. Chair. Mr. Chair, I would tend to support what Honorable Onkalawan has proposed. I believe domicile with the E is more appropriate, and like the professor has pointed out, at the end of the day, it's the definition which matters. So, but with the E, for me, it's better. It will read better.
Can I give the mic to Honorable Pile, please?
Yes, thank you very much, Mr. Chair. Very much in line with what was proposed by my two colleagues. We need to also consider the effect of taxation laws, and it is clear in taxation laws that the word domicile refers to the domicile as in being the country of origin, and the wording is with an E, not without the L. So if that will give effect, in fact, to that, then it is much more prudent for us to go by way of putting an E instead of leaving it as it is.
Thank you. Thank you, Honorable Pile. Shall we
Yes?
continue?
But maybe just before we move further, just a little one. The Article 1. I mean, just for clarity and for better presentation, I would say this is the Civil Code of the Republic of Seychelles.
Official title.
Yeah, the official title, the Civil Code of the Republic of Seychelles, because Article 2 straight away you refer to the Republic, so it would be consistent.
Yes.
That doesn't really. I think honourable member there wishes to.
Okay. Yes, Honorable Wao.
Thank you, Mr. Chair. Mr. Chair, I had two issues, but I don't know whether I would address them now. It was in respect of Article 6 and Article 7. Because now we've reached Article 10, should we conclude this preliminary articles, and then I will address later on, or I can address now?
Well, we've dealt with 10 now, domicile.
Yeah.
Okay, we've finished with that.
Okay.
Yeah, you can actually tackle 7 and 8.
6 and 8.
6 and 8. 6 and 8.
6 and 8, which is dealing with retrospective effect of legislation. I know our IGPA is silent on that, but by principles of interpretation, rules of interpretation, which is allowed under Section 13 of IGPA, we have relied on the principle that our law will not have retrospective effect unless it is expressly stated so or by implication. And it's good, but now we are introducing this concept expressed in our law. But should we not introduce it in the IGPA rather than in the code itself? This is one issue. Should I move on to Article 7?
8.
Okay. IGPA means the Interpretation and General Provision Act. So I will let the professor answer my query regarding Article 6, and then I will deal with Article
8.
7. Article
8.
7.
7.
7.
Okay.
Article 6 is a reproduction of Article 2. Article 2 Alinea 1. So the committee said, don't change. The pattern is, because this is the common law, the base set of rules, that the Interpretation Act is in general subject to the code. So we've made no change. But it is a constitutional principle.
Yeah.
So in that sense, you could argue it's not needed here.
No, what I'm saying is that we, as a consequential amendments, we have the bill whereby laws will be amended. And one of the laws that will be amended under the consequence of enactment bill will be the IGPA. So
Yes.
I was thinking, and it is better if it comes under the IGPA rather than under the civil code, because it is a rule of interpretation.
It's a more general, outer law,
Yes,
more
exactly.
general application and not simply for civil.
Yes, exactly.
Yes.
So what are we agreeing on?
Yes.
Will that come in?
So,
Yes.
we-
I think this is one I'm actually discussing with AG.
It can be done here, but otherwise, if they don't have.
Yeah, we can either take that here, we change, or we can do it on the floor.
Yeah.
We'll take note.
Yeah. Sarah is taking notes.
Yes.
Which will then be circulated to everybody, and the Bills Committee will, as usual, make a set of consensual amendments
Yes.
for acceptance on the floor.
Yes. Okay.
but maybe, Mr. Chair, the question that we can ask is it going to be an excess to have it in both, so that we don't need to change the numbering of the articles as has been presented? Will it be an excess, or
No.
will repetition in the Interpretation Act?
Yes.
Yeah.
So we can
Yes,
keep it
we
in
can
both.
keep it. Okay.
Well, in all three places, because it's also in the Constitution.
Yes. Okay. Honorable Wao, the next one.
Thank you.
Monsieur Domingue.
Thank you. Just to shed light on it, why in your code, just like because in the Code Civil, there was a provision at the time, 1804, la loi ne dispose que pour l'avenir. In our Constitution, we had a provision that Parliament may provide for retrospective legislation, but that would apply to civil matters, not penal. You can't make an offense, conduct which was not, because then it's another section which deals with it. And also that has been qualified by the court that even if Parliament can make laws which are retrospective, they cannot go against vested rights or property rights, for instance. So it's not a problem that you have a rule in it in the Constitution. IGCA will deal with both civil and criminal matters, and here civil matters. Not a problem. But the fact that you have it here is because the code initially dealt something which says que pour l'avenir, whereas we take a solution which is a bit different. The courts are developing a whole jurisprudence on that. Lois de procédure peuvent s'appliquer, effet immédiat de la loi nouvelle, loi ancienne ou l'empire de la loi nouvelle. There's a whole case law development on the matter, and I think it's not a problem to have it in the Code Civil, in the IGPA, and also if there are provisions in the Constitution which would have a bearing on it. I'm sure you have a provision which prohibits retrospective creation of criminal offense. Yeah.
Okay. Thank you, Mr. Domingue. Honorable Wao.
Yes, regarding Article 7, we are now introducing the concept of precedent, stare decisis, into our law,
Yes.
which under the present Article 6, it's not the case. And you've mentioned, Professor, that one of the reasons why the committee decided to introduce stare decisis or precedent into our law is the fact that courts in Seychelles has generally followed precedents established by the higher court. And the courts have done so because of Article 6. Because the way article, rather than Article 5, not Article 6, rather because of the way Article 5 is drafted. Article 5 presently provides that decision of the court, although not binding, shall enjoy a high persuasive authority. So this is the reason why lower courts have tended to rely or give effect to judgments of the higher court. Because it has high persuasive authority, and they can depart only for good reason. But I tend to think that when the principle of stare decisis and precedent has been followed in common law jurisdiction rather than civil law, and we have a civil law system, and I believe that Article 5, the way it is, should be kept in its present wording, because we are interfering too much with the judiciary now. And we have to bear in mind, we have Article 119 of the Constitution, which protects the independence of the judiciary. And that judiciary is not only in respect of the high court, of the higher courts, but also the lower courts. So that if a lower court feels that, look, I want to depart from, for good reason, from the earlier judgment of a higher court, the lower court can do so. I know under the principle of precedent, the lower court can still do so, but it can do so in limited circumstances. Whereas presently they have a more room to maneuver. So I believe we should keep our Article 5 the way it is and not, and basically introduce in Article 7 what Article 5 presently provides for.
Okay, thank you, Honorable. Yes, Professor?
The original commentary on Article 5 that was in the report by Professor Kloros, from memory, justified the inclusion of Article 5 not because of the French heritage, but because this was a new code for Seychelles. That was the reasoning, and there were not a lot of court cases, and the idea was there shouldn't be a stricter rule about higher decisions. Give the courts of Seychelles time to develop its own body of case law. So that was the justification then. The members of the judiciary that were present at the committee discussions had the view that that time had passed. So that is one point. The other is that it is true in the French system that there is not such a strict doctrine of precedent. However, there is a rule which has the same efficiency rationale, which is that of a jurisprudence constante. So one way or another, I think there are cultural differences, but the practical consequence is similar. A third point, which will be a matter for debate in later articles, is that the practice of the courts of Seychelles on the matter of distribution of property when an en ménage relationship breaks down is there, and there. And if I'm a litigant, it's terrible, because it means each time a different Supreme Court judge gives a different conclusion, if I have the resource, I will have to go to the Court of Appeal, which is more or less consistent on those matters. But the Supreme Court has a huge diversity of responses to the proper way to distribute property when an homenage relationship breaks down. So that is a major policy matter for later discussion. But that sort of example was also considered when the committee proposed moving to a somewhat tighter principle relating to the role of higher courts in relation to lower ones.
All right. AG?
Despite the fact that I signed the bill, it doesn't mean that I need to agree with each and every provision of it. I appreciate both arguments with regards to the doctrine of binding precedents, but at the same time, we have a system already in place where I don't think we have encountered that much problem. Whilst I appreciate what Professor has said with regards to distribution, if we may call it, distribution of property of a ménage relationship, which is more unjust enrichment. In fact, only recently we've had that change. But this, we've had for a long time un jurisprudence assez constante, but only recently we've had un réveillement de jurisprudence in this area with the case of Waïve, where the Chief Justice, for example, gave property rights to a concubine. And in fact, went even further, forced the concubine into relinquishing his property, which in some cases the court is very reluctant to do. So, but from your very argument, it allows the same court, the Supreme Court, to do the réveillement for good reasons. But so as we speak now, our law is more or less the same. So within the courts, they can do a réveillement, but then the lower courts. But often there are situations where we have very bad judgments from the Court of Appeal. You've reviewed the judgments of the Court of Appeal, which I don't have any adjective qualificatif. I've had one, for example, where Honorable Waro, where the court gave a child two fathers. How do we reconcile? So sometimes the Court of Appeal take leave of their own senses, their own legal senses, and it's only the Supreme Court that then have to bring and direct. So this allows, therefore, that the deaf, the blind doesn't lead a deaf man.
Okay, Honorable Andre?
Thank you very much. This is a very fortunate situation for one to have more than one biological father granted by the court. But I would tend to agree with what is in the code and not necessarily disagree with the AG and Honorable Wawa. But if one issue is cleared up in a law whereby a lawyer in his submission refers to that particular article and subsequently refer to a case that he thinks or the facts shows that the judge should take that particular consideration in delivering the judgment, that is, I think, clear in this law, 7. And as it goes along, as the AG stated, that the law as it is now, the court can subsequently change a ruling that they have passed. So it is clear now in 7.2 that the court may do so. So it's embedded now in the code whereas previously it was being done. So why not just leave it as it is? And I would support this, and I believe we should
Thank you.
move on with regards.
Thank you, Honorable Adoy. Can I give the mic
I want
to
to shed some light on it.
Mr. Domingue?
Yeah, it's the problem of mixed legal heritage. You see, the distinction between the French development of laws and then the English development of laws, it's how Honorable George said. At a point in time, there were various local customs. They had to do a unification of the law. In England, it was done by the judges. So when the law of a country is unified by the judges, you need a system of binding precedent. In France, there were various attempts at codification. It's only after the revolution that the unification of the law was done through Napoleon. You must bear in mind then that it's after the revolution. There was what they call then l'arbitraire de l'Ancien Régime, donc la souveraineté populaire given to the National Assembly. They had much mistrust for the judges. So they didn't want the judges to say, now we are relying on a precedent. They will tell you the authority for a rule is in the provision of the code. Not in a decision of your brother judge, because we don't trust any of you. So we had it until now, and then when we became a British colony, they set up Supreme Court, and in the Supreme Court they always tell you it has the same powers as the High Court of England. But the High Court of England adheres to a system of precedent. So you had the Supreme Court would require that there is a system of precedent. But of course, lower courts, which will have to be bound, and it doesn't prevent a court from reversing its own decision if it's bad in law. This is what this provision is about. But it's important to have the precedent because you bring some certainty to the law. If, as you say, in any area, you may have judges who become a bit original, then you bring some uncertainty in the law. Certainty must be brought by the higher court, and those lower in the hierarchy must follow it. But that won't prevent even a court lower in the hierarchy on the basis that it's wrong in law, or that there are novel circumstances, or that the provision itself requires a new understanding today, because laws have a life of their own. You will vote it, but they have a life of their own. Yeah.
What does Mauritius do?
We have a system of binding precedent. That is, what we did in Mauritius was very simple. Code 1804, there was a provision, la loi, il est interdit au juge, it's still there, il est interdit au juge de se prononcer par voie réglementaire sur les causes qui leur sont soumises. That's 1804. But we have a law, 1850, setting up the Supreme Court, says same powers. The law which is posterior implicitly repeats that provision. It is the one which is applicable. Lex posteriore derogat lex anteriore. Yeah? So it's the lex posteriori but here, right now, when the 1975 Civil Code was passed, technically, when you had the Supreme Court, it was binding precedent, but with that, you give room for no system of precedent. I think it's good you bring it back to what it should be, as it is drafted now. I mean, my view.
But at the end of the day, isn't it bonnet blanc bonnet? One says, the old principle says, not binding.
Absolutely.
Absolutely. You can, well, very persuasive. You can depart from it. The current one says binding, but you can depart from it. So both of them leave the door, leave it open for you to go through a door.
Yeah.
I think so long as that exists, you see, we must, what I think everybody agrees is that we mustn't be led into a situation where we must blindly follow, because the specificities of our country are such that we have had judgments which are questionable, and if we, in the higher courts, and if we have to blindly follow them, we have a problem. And we are also in a situation where we are still developing our jurisprudence. We're at the very beginning. I think we need to develop it a bit more before we lock it into a system.
Mr. Chair, I speak as a layman, and following the two arguments, I view it as we want a door to exist. And if this provision allows for this door to exist, then as a layman, I don't see any problems, because this is exactly what was in the previous one. It left a door. So I guess what the legal minds have to tell us is whether the door is big enough to fulfill what we are talking about. Because if the door is too small, if we want to allow an elephant to go through, but we have a small door, then we have to do something with that door. But if the door is big enough, for that to happen, then as a layman, and I got to put emphasis on that, I don't see a problem. And I mean, we've also got to be a little relaxed, but earlier on when the AG was talking about the Court of Appeal giving somebody two fathers, I think it's part of our culture, because maybe the judge was taking into consideration the local context where sometimes when a woman is pregnant, a man will say, let me add the years. So, laisse-moi mettre les oreilles. And so,
Yes, Honorable Gillet.
Thank you, Mr. Chair.
Giving an additional
Mr. Chair, I think there's a question which has not been answered. The question raised by Honorable Wawo was in relation to the article of the Constitution, and here it is prescribing the reasons where you can depart. So isn't that constraining the court in itself? Because the earlier provision was very much in line with the discretion that is provided to the courts under the Constitution. In here, you are prescribing those. You are stating what they are. So if your first reason, for instance, there's a Latin word used there, but I think
Careless.
yeah. So the Latin word which you've used in 3A, for instance, 7.3a, it just means that the previous judgment departed from the law or statute that existed. I know you lawyers love your Latin words, but I'm a lay person. The problem which begs itself now is that judge who's on that case now have to reflect on the previous judgment and now make judgment on the previous judgment. So you see, so it puts us in a precarious situation. So I don't know. Is it constitutional to have it prescribed as it is, therefore constraining that discretionary power which the court has, or should we leave it as it was, whereby that discretionary power retains its amplitude? This is what I want to clarify.
Thank you, Honorable Pillay. You want to add on that, Honorable Wao, before I give the mic to Professor?
Just to add to what has been argued or discussed so far regarding certainty in the law. It's true, one argument in favor of the doctrine of precedent is that it brings certainty in the law. But that is more to do in a common law jurisdiction where you have judge-made law, but not so much where you have statutory law, and it's only a question of interpretation. So not a question of interpretation of those legislations. So I would tend to maintain my previous stance that I believe Article 5, as presently worded, is sufficient.
This is clearly a matter for the Assembly to determine. I think the reasoning each way has been fairly canvassed. This puts greater emphasis on the judgments of the Court of Appeal than the existing law. So the idea is to have more certainty and therefore less unexpected change. If this reduces the size of the door, and there is in fact an elephant to go through, I'm wondering whether the opening of the space for the elephant doesn't properly belong with this body. So the courts have said this we believe to be the proper law, and it's not acceptable. Then on separation of powers, should there not be an amendment on that principle and say, well, yes, that elephant should have got through. We, as the legislature, are not happy with the interpretation as developed by the courts, and therefore we amend the relevant provision. Seems, certainly from a common law point of view, at a certain point, you meet the principle of separation of powers. Whose role is it to be changing basic principle? Is it the Assembly, or is it the court?
I think to curtail debate on this, it's been, I think, exhausted. We'll make a note, and the Bills Committee, which is going to consider all of these suggestions, will put a proposal in its report for the House to consider when we come to the vote.
And also, we should not be seen that we interfering too much on the court, the independence of the judiciary. Okay. Do we have any more queries with regards? You want to go up to 14 before we break?
Before,
yes. Yes.
I just wanted the raison d'être for not including the alinéa 2, the second paragraph of article, the former article 2, and the new article for retroactivity of laws 6, because as Professor said, you don't want this to affect vested right, whereas in the current law, this is very express. Whereas now, if somebody, a legislator, will look at Article 6 and say, okay, if it's expressly stated, I can have a law with retroactive effect. Whereas paragraph 2 specifically said it shall not apply to vested rights which are immediately enforceable. So, but the committee decided not to. Exactly.
Because of the Constitution. Wasn't that it? Yeah. Adequately protected.
Okay, shall we? Shall we continue?
Yeah.
Yes.
The remaining articles are reproduction of the rules in the current code, and I think if you're following, if you had both texts, Article 13, which relates to the impact of foreign laws, currently is at the end of the code, and it has here been brought forward to be with the other provisions which relate to the impact of foreign law in Seychelles. The principles have not changed. The principle that if there's a mortgage created on land in Seychelles, it has no validity unless it's valid here. So someone can't go have an English mortgage and then claim access to the land here. It must be, that's the existing principle. It's in, I think, 2128, and it seems a little bit out of place there. The committee thought to bring it forward to the other rules which relate to interaction with the laws of other countries.
But with regards to this, Professor, mortgage, unless we keep the mortgage within the code, but if we're going to extend it further, we have under our law mortgages with regards to vessel under the Merchant Shipping Act. We have also mortgages in regards to aircraft under the Seychelles Civil Aviation Act. So whilst those mortgages also, they're specially regulated by their own law, then they will have to...
They have priority.
Yes, and they will have also to be registered in accordance with the law. So that, but however, if somebody, for example, who has given a mortgage over a vessel, despite the fact it's not registered under domestic law, then the person will not be prohibited from enforcing the mortgage wherever the vessel or the craft is situated. Because we should not be restricted to land unless it's specifically said a contract in a foreign country cannot create a mortgage on immovable property. Because now it says property.
Yes, Honorable Ade.
Which is the current law.
Any contract by anyone would not be applicable if made in another country in Seychelles. No, why I'm asking this is that, Egicia, or is it in respect of property and simply with respect to the matrimonial issues? Because otherwise we have a lot of contracts that are made outside Seychelles by relevant authorities, binding the country in terms of mortgages, let's say a loan. I'm just trying to be clear so that everybody is clear with what is going on and what really are we addressing. If this is specifically to property that emanates from a marriage or from heirs or what? Thank you.
Yes, Professor? Yeah,
I think it's Article 1400, starting with the property of a marriage. The current situation in Seychelles is that everyone owns their own property, and whether they're married or not. The only time that property right might be changed is when the relationship ends and there's a court order saying one party has a right to, for instance, the house which is in the other's name. So an exception is if the parties make a matrimonial contract. And like any other contract, then you come back to Article 14, which is the current law, and that says that every contract will be governed by the law which is most relevant to it. So if those parties had married in Germany while they were resident there, that would be governed by the German law. And then the parties they split up in Seychelles, there will be an argument, perhaps, and the court will say, what is the law that properly applies to that contract? And they'll say, oh, they're both German nationals, they made it in Germany, they've got bank accounts in Germany, therefore we will ask for proof, what is the German law, and we will follow that. So that is the standard rule and no change, and that is set out in Article 14 now. The the rule on mortgages is general, and it's the current rule in 2128. So the committee decided to bring it forward. Question is then, well, if the foreign contract relates to a mortgage, the mortgage has no effect because 13 derogates. And historically it would be clear that the concern was with land in Seychelles, and you'll see that the rules relating to land are spelled out in Article 12. What governs distribution of land is always the law of the place where the land is. So that's that. Now, the question becomes, what about, for instance, ships and aircraft? Are they immovable or are they movable? Article 4 says that unless there is express provision, maybe in the civil aviation law or the merchant shipping law, then the code provision prevails. So the question then becomes, what does the civil aviation or the merchant shipping law say? But as we read it here today, if it has no express or necessarily implied application, then the mortgage has to comply with Seychelles law.
Be registered, basically.
Yes. And
Okay. Yes, Honourable Wong.
Regarding the point raised by the AG, true, Article 2128, our present Article 2128, has now been brought under Article 13, the proposed Article 13. And the point the AG has made, presently we have Article 2120. 2120, which reads, nothing in the present code shall affect the provisions of shipping or air law relating to ships, sea vessels, and aircraft. That is the part dealing with mortgages. Okay? So it saves expressly mortgage issues regarding ships or aircraft. Now, but this article now is going to be repealed. It's not there in the proposed code. I believe we should keep this for clarity, as an abundance of caution, or for clarity. For clarity.
21, 20.
Yes. Okay.
True.
Okay. Members, I think we'll take a break from now. We finish 1 to 14, and now we need to decide what time we want to reconvene. We keep it at 2, or you want to start 30, 12, 17? No, but we need to give some time also to SBC for news and all that. We're running late already. So we start at 2, and we will tackle 15 to 18 onwards. All right, so the meeting is adjourned and we reconvene at 2 p.m. Thank you.